get your company set up right from the beginning, and you can save yourself a lot of grief later. Where you have challenges is if you take on investors. You may not know this, but if you set up your company with Companies House, you have one of the most awful documents called an out-of-the-box Articles of Association that you signed up for when you created your company. And it leaves you, if you take on investors, you are left with all sorts of liabilities that could get you in real trouble because you didn't look into what's actually in there. And I remember when I first set up the company, we got, a gazillion things to do. We're trying to build a website. We realize that we've got to register our company. We go on Companies House. We try and do it as quickly as we can. We tick a few boxes. Did you know that you created an Articles of Association in that process? A lot of people don't know that they did. I didn't know that we did in that process. But it's not fit for you to take on investors if you're using the one that you used when you set up with Companies House. So here's what you need to know in order to raise finance from investors. Here's the bits you need to know. And I'll go through each one of these individually, the bits which I think are really important. So the terms of your company is really what outlines everything about the investment that investor might do and what happens when things go wrong or things go right. And it's okay when you're kind of dawdling along, but when things go wrong or things go right, these things really matter and people refer to them. So here's the main things that I think you need to consider. Firstly, you have two ways of creating terms for your company. And you could do them both or you could do one of them. One of them is you create an Articles of Association. So every company, every UK limited company has an Articles of Association with Companies House, which outlays the procedure of what needs to happen in your company. On top of that, you could have what's called a shareholders agreement. And a shareholders agreement is what I signed when we took on investment from Peter Hargreaves. Now, I didn't really read too deeply into that, but now I read very deeply into that, partly because Bliss is, the legal person that quite happily can read through 50 pages of terms and conditions and enjoy it as well. Here's the difference. The difference between articles and shareholders agreement, whether you have one or whether you don't. Firstly, shareholders agreement is completely optional. Articles of Association is compulsory. You all have one already if you've got a company. The difference is privacy. So the articles is a fully public document that anyone that wants to do any research on you can download from Companies House and get those details. A shareholders agreement is completely private. So nobody can access that apart from the shareholders have a right to actually access that if they're a shareholder in your company. The first thing is privacy. The second thing is how to make changes. With the Articles of Association, the way that you make changes is by having a resolution with your board of directors. With the shareholder agreement, you have to have a meeting with all your shareholders and get them all to sign any changes. Okay? So if you have a shareholders agreement, if you're looking at crowd investing, then you're going to have to get 150 people if you've got 150 shareholders if you decide that you later want to raise finance. If you use the Articles of Association, then you can make changes through a board resolution. Okay? So anyone that pitches on Bank to the Future, we focus our attention here because you might have a lot of shareholders if you're raising finance from the crowd. And there we go. The other thing is the signatures. So the signatures to change the Articles of Association is the directors. The signature to change the shareholders agreement is all shareholders. Okay? So if you're going to be crowd investing, focus on Articles of Association and forget about shareholder agreements. Okay? If you're going to take on one investor, they might want to do a shareholders agreement, but read very, very carefully what they put in that shareholders agreement because it will affect you whether you succeed or fail later. So that's where you set out the terms. You all have a benchmark terms when you're taking on the investment. The next thing you need to look at is voting rights. So, essentially when people buy shares in your company, they're buying voting rights in your company, in most cases. So you need to think about what level of protection you might need and also what level of protection the investor might need. You want to do a fair deal here, otherwise you're not going to take on any investors. So there's 3 types of shares that you need to consider. You can either do A shares, which is where you give people full voting right as full ordinary shares. You could give people preference shares, and preference shares is what venture capitalists will look for. They'll look for preferential treatment if the company goes bust. They'll look for preferential treatment if the company goes well. They'll look for preferential treatment if you don't hit the financial forecast that you told them, and they'll have ratchet clauses where they'll get more equity in your company the more you don't hit the targets that you set them. Okay? So preferential shares. Now here's the beauty. They won't qualify for SEIS or EIS if you give them preference shares. They can't have any preference. So therefore, you don't need to have that conversation if you're raising finance through the scheme. The final type of share is what's called a B share. And a B share is where you put some kind of non-voting rights. So with Bank to the Future, when we raised our finance, we had a minimum investment of 5 grand. If you invested 5 grand, you didn't get voting rights. If you invested 25 grand, you got voting rights. Okay? So it's just a way of you can create these different classes to make, get people to invest more, or if people are going to be investing little amounts, like 100 quid, then you don't want to have them have voting rights, because if you sell your company later, you then got to get permission to sell the company if you don't do it right. Okay? So once you've got your terms right, you then decide what type of voting rights you want to give to people when you're selling the shares. Get this right up front, otherwise they'll dictate the terms. Okay? The next thing you need to think of in the legal side is the tax bit. And we've already covered this to some degree. As we said, HMR gave us this brilliant thing where they said that you won't qualify if they get preferential treatment over your shares. The thing you need to be aware of is that you need to issue new shares. You can't sell your shares, you need to issue new shares. Otherwise it won't qualify. So if you're trying to do this tax efficiently, you need to create some new shares. You can't. So when you set up your company, you set up basically a nominal value of what a share is worth, and you set up the number of shares in your company. You probably created a number like 100 shares at nominal value 1p. When you're doing for SEIS, you need to create 100 new shares, okay? Rather than giving them 50 of your shares. Otherwise it won't qualify. So there's another tax thing that you need to consider. The other things you need to consider with the legal side is what happens if you sell your company. This one's really, really important. So I'm not going to go through, there's 3 things I think that you need. These 3 things. Essentially, without me getting into the definitions of exactly how these work, what it means is if you have lots of shareholders and you decide that you want to sell your company, then someone that invested a tenner in your company can't stop you from selling. They have to drag along with you. They have to tag along, okay? It also means that if someone offers to buy your company, that they also get the opportunity to sell their shares at the same rate, okay? And preemption also means that if you one day want to sell your company and you get an offer, it means that they also have to offer the shareholders those shares as well. So that's fair to the shareholders. Just write down those 3 things. Those are 3 things you need. Those are 3 things very important. You don't have any of those in your company at the moment if you've got the Articles of Association with Companies House. Therefore, if you take on investors, you're at real risk of what happens when that company either goes bust or goes well. Those are the main things. There's lots of other things. Those are the main things I think are really important if you're taking on lots of investors. The final thing to be aware of is the compliance side. So there's just 2 rules you need to know if you're going to be pitching investors. The first one is you must be an approved financial promotion in order to pitch investors. What that means is that every piece of documentation in your business plan has been legally verified and audited so that it's fair and not misleading. That's what you're meant to do. That's the rules to do that. You must be approved financial promotion. The second rule is you must get investors to self-certify themselves as either being high net worth or sophisticated investors, which means that before you even pitch them, before you show your business plan, you are breaking the law if you don't get them to self-certify that they're high net worth or sophisticated investors. So what I'd like to do is give you a way to not have to worry about any of that. Would you like that?
Yes.
To not have to do any of that? Okay. If you pitch on BnkToTheFuture.com, guess what? Here's the cost saving. Essentially what we try to do at Bank to the Future is take all of the restrictive upfront fees, compliance, headaches that you as entrepreneurs don't want to do, digitized it, automated it, and take care of it so you can just go out there and do what you're meant to be doing. So traditionally, if you want to be an approved financial promotion, you need to engage a corporate financier who's FSA approved, and the minimum investment is 35K. If you're raising 100K, that's 35% of your investment gone, just to be compliant with FSA rules. If you do it with us, then we'll only charge you a success fee. We won't charge you anything up front, and we are already an approved financial promotion so that you don't need to do any of this. You don't need to spend that bill. What we charge is if you raise your funds, if you raise 100 grand, we'll give you 95 grand, okay? What you do when you set a crowd investment on Bank to the Future is you set a goal by which you want to achieve. So if you're looking to raise 100 grand, you also set something else which is unique to us. And that is that you set a minimum goal. And a minimum goal might be, this business can still go ahead if I only raise 50. But I want to raise 100 in order to execute this business plan. But if I raise 50, I can still go ahead. And the way that it works is if anyone invests in you and you hit your 50 grand, your minimum goal, then you get charged a higher commission, and the investors have the option to not invest if they're not happy anymore. But you still get your money. If you go with anyone else, you have to give all the money back if you don't hit your target. If you hit your full goal, because the reason we charge a higher amount, which might seem counterintuitive, is because we still want you to hit your main goal. We want you to be motivated. We don't want you to relax after hitting your minimum goal. We want you to be motivated to go all the way. So in which case, you pay the smaller fee. Make sense? Okay. You pay nothing up front, and all the financial promotion stuff is taken care of. Traditionally, you'd have to set up A shares and B shares, and you'd need to engage a lawyer in order to either create a shareholders agreement or an articles of association which defines exactly what happens with A shares and B shares. The legal fee, you're probably looking at about 3 grand if you get a good lawyer. We paid 5 because we like to get really good lawyers. If you do it with us, we've paid the bill for you, we'll set them up for you, it's all done. It's all done as part of the process. If you were raising finance, traditionally, you'd want to update your articles of association, put drag along, tag along, and pre-emption. You're probably looking at a legal fee of about 3 grand in order to do that. We'll do that for you, so you don't have to pay any of that up front. When you issue your share certificates, to do this properly and to do anti-money laundering and to comply with the process you're meant to follow, you'd engage an accountant to do that, and it would normally cost you a couple of grand. And this is why raising finance for small business, remember that little bit there? Because it's not worth paying all this stuff if you're only raising 100K. If you do it with us, then we only charge you the accountant bit that will do this. We'll get an FSA approved person to do that. And that will come off the funds only if you raise your finance, only if you issue shares. Okay? So if you raised your finance, you'd pay 5% plus this. That's what you'd pay. You'd also need to issue the shares in a compliant process. Normally, you'd pay a consultant to do that. They'd charge you about £1 grand in order to make sure you follow the SEIS procedure, check that you qualified. With us, we'll make sure if you use our system, you can't break the rules in terms of the actual process of issuing shares and taking the money in at the right time. It doesn't mean that if you are, you've lied about being a qualifying trade, there's still responsibility on you, but the actual order of taking finance you won't get wrong, so you won't need to pay that. To certify all of the investors as high net worth and sophisticated is a document that will probably cost you about £1,000, or you could get a turnkey one from online. With us, anyone that signs up and invests in you has automatically been through that process, and they've been either certified as high net worth or sophisticated within the process of investing in you, so you don't need to worry about that. Anti-money laundering, you'd normally pay a credit agency in order to do that if you want to be compliant. With us, we've done that all for you. It's covered in the fee, and we've integrated with the credit rating agencies. So your upfront fee to raise finance is round about, and that's pretty conservative. Most people pay around about 50 grand in order to do this process correctly. With us, if you don't raise your finance, you won't pay a penny. Okay? So that's the market that we wanted to play in. We wanted to take all of this shit and make it so that it's completely compliant and unrestrictive. So that's the legal bits. You'll be glad that the tax and the legal bits are all over.